Welcome back to the Brian Fagan YouTube channel. I'm Oya, and today we're tackling a critical question that often comes up during divorce proceedings. Can property owned before marriage be divided in a Texas divorce? Whether you brought assets into your marriage or your spouse has, understanding how these assets are handled under Texas law is essential. Let's dive in and break it all down for you. In Texas, any property owned by either spouse before the marriage is generally considered separate property. Separate property is not subject to division during a divorce, as it belongs exclusively to the individual who owned it prior to the marriage. Examples of separate property include a house, a car, or investments you acquired before tying the knot. However, just because property was owned before the marriage doesn't mean there won't be complications. One of the key challenges in a divorce is proving that an asset is indeed separate property. Texas courts presume that all property acquired during the marriage is community property, meaning it's subject to division between the spouses. If you want to claim certain assets are separate property, you'll need to provide clear and convincing evidence, often through documents like deeds, account statements, or purchase receipts. Another potential complication arises when separate property becomes commingled with community property during the marriage. For example, if you owned a home before the marriage, but used marital funds to pay the mortgage or make improvements, your spouse may have a claim to a portion of the home's increased value. Similarly, if funds from a separate bank account were mixed with marital income, it can become challenging to distinguish what is separate and what is community property. In these cases, a process called tracing is often necessary to untangle the assets and determine their proper classification. It's also important to consider retirement accounts, investments, and other assets that may have been acquired before the marriage but grew in value during the union. While the original value may be separate property, any appreciation or income earned during the marriage could be classified as community property and subject to division. If you're facing a divorce and have concerns about property owned before your marriage, it's essential to consult an experienced Texas family law attorney. They can help you gather the necessary evidence to protect your separate property and ensure that any community property is divided fairly. Texas law strives for equity, but that doesn't mean a 50-50 split all the time. Having the right legal guidance can make all the difference. Thank you for joining us today. If you found this video helpful, don't forget to like, subscribe, and turn on notifications for more insights into Texas family law. At the Law Office of Brian Fagan, we're here to provide the guidance you need to navigate the complexities of divorce. If you have questions about your specific situation, reach out to us for a consultation. Until next time.
Thanks for tuning in to the end. We understand that divorce can be expensive depending on the situation. That's why we're offering our Do-It-Yourself Texas Divorce e-course. You can get access to this e-course by clicking on the link in the description below. Catch you in the next video.